The House has informed the administration that defiance of subpoenas at the direction or behest of the President or the White House could justify an adverse inference against the President. In light of President Trump's unlawful and unqualified direction that governmental officials violate their legal responsibilities to Congress, as well as his pattern of witness intimidation, the House may reasonably infer that their testimony would be harmful to the President, or at least not exculpatory. If this evidence were helpful to the President, he would not break the law to keep it hidden, nor would he engage in public acts of harassment to scare other witnesses who might consider coming forward. One noteworthy result of President Trump's obstruction is that the House has been improperly denied testimony by certain government officials who could have offered first-hand accounts of relevant events. That does not leave the House at sea. There is still robust evidence, both documentary and testimonial, bearing directly on his conduct and motives. But, especially given the President's obstruction of Congress, the House is free, under the Constitution, to consider reliable testimony from officials who overheard or later learned about statements by the President to witnesses whose testimony has been blocked. To summarize, just like grand jurors and prosecutors, the House is not subject to rigid evidentiary rules in deciding whether to approve articles. Members of the House are trusted to fairly weigh evidence in an impeachment inquiry. Where the President illegally seeks to obstruct such an inquiry, the House is free to infer that evidence blocked from its view is harmful to the President's position. It is also free to rely on other relevant, reliable evidence that illuminates the ultimate factual issues. The President has no right to defy an impeachment inquiry and then demand that the House turn back because it lacks the very evidence he unlawfully concealed. If anything, such conduct confirms that the President sees himself as above the law and may therefore bear on the question of impeachment. C. Abuse of presidential power is impeachable. The powers of the President are immense, but they are not absolute. That principle applies to the current President just as it applied to his predecessors. President Nixon erred in asserting that when the President doesn't, that means it is not illegal. And President Trump was equally mistaken when he declared that he had the right to do whatever I want as president. The Constitution always matches power with constraint. That is true even of powers vested exclusively in the chief executive. If those powers are invoked for corrupt reasons or in an abusive manner that threatens harm to constitutional governance, the President is subject to impeachment for high crimes and misdemeanors. This conclusion follows from the Constitution's history and structure, As explained above, the framers created a formidable presidency, which they entrusted with the executive power and had a host of additional authorities. For example, the president alone can confer pardons, sign or veto legislation, recognize foreign nations, serve as commander-in-chief of the armed forces, and appoint or remove principal officers. The president also plays a significant, though not exclusive, role in conducting diplomacy, supervising law enforcement, and protecting national security. These are daunting powers for any one person to wield. If put to nefarious ends, they could wreak havoc on our democracy. The framers knew this. Fearful of tyranny in all its forms, they saw impeachment as a necessary guarantee that presidents could be held accountable for how they exercised executive power. Many delegates at the Constitutional Convention and state ratifying conventions made this point, including Madison, Randolph, Pinckney, Stillman, and Iredell. Their view was widely shared. As James Wilson observed in Pennsylvania, we have a responsibility in the person of our president, who is possessed of power, since far from being above the laws, he is amenable to them, by impeachment. Hamilton struck the same note. In Federalist number 70, he remarked that the Constitution affords Americans the greatest security that they can have for the faithful exercise of any delegated power, including the power to discover with facility and clearness any misconduct requiring removal from office. Impeachment and executive power were thus closely intertwined in the framers' constitutional plan. The president could be vested with awesome power, but only because he faced removal from office for grave abuses. The architects of checks and balances meant no exceptions to this rule. There is no power in the Constitution that a president can exercise immune from legal consequence. The existence of any such unchecked and uncheckable authority in the federal government would offend the bedrock principle that nobody is above the law. It would also upend the reasons why our framers wrote impeachment into the Constitution. The exact forms of presidential wrongdoing that they discussed in Philadelphia could be committed through use of executive powers, and it is unthinkable that the framers left the nation defenseless in such cases. In fact, when questioned by Mason in Virginia, Madison expressly stated that the president could be impeached for abuse of his exclusive pardon power, a view that the Supreme Court later echoed in Ex parte Grossman. By the same token, a president could surely be impeached for treason if he fired the Attorney General to thwart the unmasking of an enemy spy in wartime. He could be impeached for bribery if he offered to divulge state secrets to a foreign nation, conditioned on regulatory exemptions for his family business. Simply put, the fact that a power is exclusive to the executive, that is, the president alone may exercise it, does not mean the the power cannot be exercised in clear bad faith, and that Congress cannot look into or act upon knowledge of that abuse. The rule that abuse of power can lead to removal encompasses all three branches. The impeachment clause applies to the president, vice president, and civil officers of the United States, including Article 3 judges. There is no exception to impeachment for misconduct by federal judges involving the exercise of their official powers. In fact, the opposite is true. If, in the exercise of the powers with which they are clothed as ministers of justice, judges act partially or maliciously or corruptly or arbitrarily or oppressively, they may be called to an account by impeachment. Similarly, if members of Congress exercise legislative power abusively or with corrupt purposes, they may be removed pursuant to the expulsion clause, which permits each House of Congress to expel a member with the concurrence of 2/3. Nobody is entitled to wield power under the Constitution if they ignore or betray the nation's interests to advance their own. This is confirmed by past practice of the House. President Nixon's case directly illustrates the point. As head of the executive branch, he had the power to appoint and remove law enforcement officials, to issue pardons, and to oversee the White House, IRS, CIA, and FBI. But he did not have any warrant to exercise these presidential powers abusively or corruptly. When he did so, the House Judiciary Committee properly approved multiple articles of impeachment against him. Several decades later, the House impeached President Clinton. There, the House witnessed substantial disagreement over whether the president could be impeached for obstruction of justice that did not involve using the powers of his office. But it was universally presumed and never seriously questioned that the president could be impeached for obstruction of justice that did not involve those powers. That view rested firmly on a correct understanding of the Constitution. Our Constitution rejects pretensions to monarchy and binds presidents with law. A president who sees no limit on his power manifestly threatens the republic. D. Presidential pretexts need not be accepted at face value. Impeachable offenses are often defined by corrupt intent. To repeat Iredell, the president would be liable to impeachments if he had acted from some corrupt motive or other, if he was willfully abusing his trust. Consistent with that teaching, both treason and bribery require proof that the president acted with an improper state of mind, as would many other offenses described as impeachable at the Constitutional Convention. Contrary to occasional suggestions that the House may not examine the president's intent, an impeachment inquiry may therefore require the House to determine why the president acted the way he did. Understanding the president's motives may clarify whether he used power in forbidden ways, whether he was faithless in executing the laws, and whether he poses a continuing danger to the nation if allowed to remain in office. When the House probes a president's state of mind, its mandate is to find the facts. There is no room for legal fictions or lawyerly tricks that distort a clear assessment of the president's thinking. That means evaluating the president's explanations to see if they ring true. The question is not whether the president's conduct could have resulted from innocent motives. It is whether the president's real reasons, the ones actually in his mind as he exercised power, were legitimate. The framers designed impeachment to root out abuse and corruption. Even when a president masks improper intent with cover stories. Accordingly, where the president's explanations of his motives defy common sense or is otherwise unbelievable, the House is free to reject the pretextual explanation and to conclude that the president's false account of his thinking is itself evidence that he acted with corrupt motives. The president's honesty in an impeachment inquiry, or his lack thereof, can thus shed light on the underlying issue. President Nixon's case highlights the point. In its discussion of an article of impeachment for abuse of power, the House Judiciary Committee concluded that he had falsely used a national security pretext to direct executive agencies to engage in unlawful electronic surveillance investigations, thus violating the constitutional rights of citizens. In its discussion of the same article, the committee also found that President Nixon had interfered with the Justice Department by ordering it to cease investigating a crime on the pretext that it involved national security. President Nixon's repeated claim that he had acted to protect national security could not be squared with the facts. And so the committee rejected it in approving articles of impeachment against him for targeting political opponents. Testing whether someone has falsely characterized their motives requires careful attention to the facts. In rare cases, some implausible, fantastic, and silly explanations could be found to be pretextual without any further evidence. Sifting truth from fiction, though, usually demands a thorough review of the record and a healthy dose of common sense. The question is whether the evidence tells a story that does not match the explanation. Because court assesses motive all the time, they have identified warning signs that an explanation may be untrustworthy. Those red flags include the following. First, lack of fit between conduct and explanation. This exists when somebody claims they were trying to achieve a specific goal, but then engaged in conduct poorly tailored to achieving it. For instance, imagine the president claims that he wants to solve a particular problem. Then he ignores many clear examples of that problem, weakens rules meant to stop it from occurring, acts in ways unlikely to address it, and seeks to punish only 2 alleged violators, both who happen to be his competitors. The lack of fit between his punitive conduct and his explanation for it strongly suggests that the explanation is false, and that he invented it as a pretext for corruptly targeting his competitors. Second, arbitrary discrimination. When someone claims they were acting for a particular reason, look to see if they treated similarly situated individuals the same. For example, if a president says that people doing business abroad should not engage in specific practices, does he punish everyone who breaks that rule, or does he pick and choose? If he picks and chooses, is there a good reason why he targets some people and not others? Or does he appear to be targeting people for reasons unrelated to his stated motive? Where, similarly, situated people are treated differently, the president should be able to explain why. If no such explanation exists, it follows that hidden motives are in play. Third, shifting explanations. When someone repeatedly changes their story, it makes sense to infer that they began with a lie and may still be lying. That is true in daily life, and it is true in impeachments. The House may therefore doubt the president's account of his motives when he first denies that something occurred, then admits that it occurred but denies key facts, then admits those facts and tries to explain them away, and then changes his explanation as more evidence comes to light. Simply stated, the House is not required to exhibit a naivete from which ordinary citizens are free. Fourth, irregular decision-making. When someone breaks from the normal method of making decisions and instead acts covertly or strangely, there is cause for suspicion. As the Supreme Court has reasoned, the specific sequence of events leading up the challenged decision may shed some light on the decision-maker's purposes, and departures from the normal procedural sequence might afford evidence that improper purposes are playing a role. There are many personnel and procedures in place to ensure sound decision-making in the executive branch. When they are ignored or replaced by secretive, irregular channels, the House must closely scrutinize presidential conduct. Finally, explanations based on falsehoods, where someone explains why they acted a certain way, but the explanation depends on demonstrably false facts, then their explanation is suspect. For example, if a president publicly states that he withheld funds from a foreign nation due to failure to meet certain conditions, but the federal agencies responsible for monitoring those conditions certify that they were satisfied, the House may conclude that the president's explanation is only a distraction from the truth. When one or more of these red flags is present, there is reason to doubt that the president's account of his motives is accurate. When they are all present simultaneously, that conclusion is virtually unavoidable. Thus, in examining the president's motives as part of an impeachment inquiry, the House must test his story against the evidence to see if it holds water. If it does not, the House may find that he acted with corrupt motives and that he has made false statements as part of an effort to stymie the impeachment inquiry. E. Attempted presidential misconduct is impeachable. As a matter of settled constitutional law and contrary to recent suggestions otherwise, attempted presidential wrongdoing can be impeachable. This is clear from the records of the Constitutional Convention. In the momentous exchange that led to adoption of high crimes and misdemeanor standard, Mason championed impeaching presidents for any great and dangerous offenses. It was therefore necessary, he argued, to avoid a narrow standard that would prevent impeachment for attempts to subvert the Constitution, with emphasis added. Then, only minutes later, it was Mason himself who suggested high crimes and misdemeanors as the test for presidential impeachment. The very author of the relevant constitutional text thus made clear it must cover attempts. The House Judiciary Committee reached this conclusion in President Nixon's case. Its analysis is compelling and consistent with Mason's reasoning. In some of the instances in which Richard M. Nixon abused the powers of his office, his unlawful or improper objective was not achieved. But this does not make the abuse of power any less serious, nor diminish the applicability of the impeachment remedy. The principle was stated by Supreme Court Justice William Johnson in 1808. If an officer attempts an act inconsistent with the duties of his station, it is presumed that the failure of the attempt would not exempt him from liability to impeachment. Should a president head a conspiracy for the usurpation of absolute power, it is hoped that no one will contend that defeating his machinations would restore him to innocence. Gilchrist versus Collector of Charleston, case 355-365, number 5420 C DSC 1808, in parentheses and all that stuff. Adhering to this legal analysis, the committee approved articles of impeachment against President Nixon that encompassed acts of attempted wrongdoing that went nowhere or were thwarted. That includes President Nixon's attempt to block an investigation by the Patman Committee into the Watergate break-ins, his attempt to block testimony by former aides, his attempt to narrow and divert the Senate Select Committee's investigation, and his attempt to have the IRS open tax audits of 575 members of George McGovern's staff and contributors to his campaign at a time when McGovern was President Nixon's political opponent in the upcoming 1972 presidential election. Moreover, the article of impeachment against President Nixon for abuse of power charged that he attempted to prejudice the constitutional right of an accused to a fair trial. History thus confirms that defiance by his own aides do not afford the president a defense to impeachment. The nation is not required to cross its fingers and hope White House staff will persist in ignoring or sidelining a president who orders them to execute high crimes and misdemeanors. Nor can a president escape impeachment just because his corrupt plan to abuse power or manipulate elections was discovered and abandoned. It is inconceivable that our framers authorized removal of presidents who engaged in treason or bribery, but disallowed the removal of presidents who attempt such offenses that are caught before they succeed. Moreover, a president who takes concrete steps towards engaging in impeachable conduct is not entitled to any benefit of the doubt. As one scholar remarks, in the context of attempts to manipulate elections, when a substantial attempt is made by a candidate to procure the presidency by corrupt means, we may presume that he at least thought this would make a difference in the outcome, and thus we should resolve any doubts as to the effects of his efforts against him. Common sense confirms what the law provides. A president may be impeached where he attempts a grave abuse of power, is caught along the way, abandons his plan, and subsequently seeks to conceal his wrongdoing. A president who attempts impeachable offenses will surely attempt them again. The impeachment power exists so that the nation can remove such presidents from power before their attempts finally succeed. F. Impeachment is part of democratic governance. As House Judiciary Committee Peter Rodino emphasized in 1974, it is under our Constitution, the supreme law of our land, that we proceed through the sole power of impeachment. Impeachment is part of democratic constitutional governance, not an exception to it. It results in the president's removal from office only when a majority of the House and then a supermajority of the Senate conclude that he has engaged in sufficiently grave misconduct, that his term in office must be brought to an early end. This process does not nullify the last election. No president is entitled to persist in office after committing high crimes and misdemeanors. And no voter is entitled to expect that their preferred candidate will do so. Under the Constitution, when a president engages in great and dangerous offenses against the nation, thus betraying their oath of office, impeachment and removal by Congress may be necessary to protect our democracy. The framers considered relying solely on elections rather than impeachment to remove wayward presidents, but they overwhelmingly rejected that position. As Madison warned, waiting so long might be fatal to the republic, particularly where the president's misconduct is aimed at corrupting our democracy. Relying on elections to solve the problem is insufficient. It makes no sense to wait for the ballot box when a president stands accused of interfering with elections and is poised to do so again. Numerous framers spoke directly to this point at the Constitutional Convention. Impeachment is the remedy for a president who will do anything, legal or not, to remain in office. Allowing the president a free pass is thus the wrong move when he is caught trying to corrupt elections in the final year of his first 4-year term, just as he prepares to face the voters. Holding the president accountable for high crimes and misdemeanors not only upholds our democracy, but also vindicates the separation of powers. Representative Kastermeyer explained this well in 1974. The power of impeachment is not intended to obstruct or weaken the office of the presidency. It is intended as a final remedy against executive excess, and it is the obligation of the Congress to defend a democratic society against a chief executive who might be corrupt. The impeachment power thus restores balance and order when presidential misconduct threatens constitutional governance. 7. Conclusion. As Madison recognized, in framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governed, and in the next place oblige it to control itself. Impeachment is the House's last and most extraordinary resort when faced with a president who threatens our constitutional system. It is a terrible power, but only because it was forged to counter a terrible power, the despot who seems himself to be above the law. The consideration of articles of impeachment is always a sad and solemn undertaking. In the end, it is the House, speaking for the nation as a whole, that must decide whether the president's conduct rises to the level of high crimes and misdemeanors warranting impeachment. Thank you for listening. This is a very important document. This is the House Judiciary Committee explaining our history of impeachment and the importance and solemn duty that impeachment encases. God bless you. God bless these United States of America.